Hi, everyone. This is Jennifer Clark. I'm the Operations Coordinator with the New York State Coalition Against Domestic Violence. The time is now 1 o'clock, and in the interest of time, we're going to get started. Before I hand this webinar over to our Director of Public Policy and Advocacy, Joan Gerhardt, to go through the legislative review, just going to go over a few housekeeping items for today. All phone lines are going to be muted throughout the presentation, so we do ask that if you have any questions that you put them in the chat box through the presentation, and we'll do our best to answer those as they come up, and we will also have time at the end for a question and answer period. We are recording today's webinar, so if you want to come back and can't stay for the full presentation, you will have access to that, as well as a copy of the presentation slides, which will be sent out in a follow-up email to everyone. And with that, I'm going to hand it over to Joan.
Well, thank you, Jen, and thank you for your help organizing today's webinar. Welcome, everyone, to our webinar to review the 2020 legislative session. I was a little nervous to schedule this event on Friday the 13th. Hopefully, the gods will smile on us and our technology will work and we won't have any difficulties. But I do want to take you through some of the more notable actions during the session. You know, this obviously was a really interesting session. It was an abbreviated session because of COVID. The expected session was supposed to go through June 2nd, and it was cut short pretty much right after the legislature and governor approved the state budget on April 2nd. There was some activities that happened after that, particularly related to the COVID-19 response, as well as some police reforms, which we're going to review. But for the most part, once the state budget was approved, there unfortunately wasn't the ability for the legislature to pass, the dozens of bills that typically happen between, early April and June when they adjourn. So just to give you an idea, last year in 2019, we had well over 900 bills be approved by both the Assembly and Senate. Now that was far in excess to what had been done in the years prior, 2018 and before that, because in 2019, we had the Democrats controlling the majority in both the Assembly and Senate. So there was a lot more agreement with respect to legislation. It was a huge year. And we also saw many, many pieces of domestic violence related legislation passed in 2019. This year, to give you a frame of reference, there were only 413 bills. So, less than half that passed in both the Assembly and the Senate. And at this point in time, the governor has signed about 250 of those bills. I believe he might have vetoed one or two, and we're waiting to see his action, either signing them into law or vetoing the remainder before the end of the year. Now, with respect to domestic violence legislation specifically, we certainly didn't have the wide array of legislation that passed in 2019, but there were still some really important pieces of legislation that moved through that I want to be sure everyone's aware of in the work that you do to support domestic violence survivors every day. Now, within the context of the legislative session, I did want to briefly mention there were a lot of other activities going on as well. You might have seen that OCFS did a pretty comprehensive review of the regulations pertaining to residential and non-residential DV programs in the state. And those changes became effective also in April of this year. They are really comprehensive, and NYSCADV and OCFS are going to be collaborating on a separate webinar and training to review all of those changes. I know we've been talking quite a bit over the last several years about many of those tweaks and modifications in the regs. So we'll be back to you on that. I'm not going to cover that in today's webinar. We'd probably be here for the rest of the afternoon if I was going to do that. We also saw the state, very importantly, establish two task forces. One was established in 2019, and some of you on today's webinar might have been participating in that task force. as well as a special COVID-related emergency task force focusing on domestic violence survivors' needs in 2020. So even though the legislative session was a little abbreviated, there's been a lot of discussion about domestic violence and the needs of survivors during COVID. And you'll see some of those initiatives and efforts woven through today's presentation. So I think with that, we're going to get started. I am looking at the chat box. I'm going to be stopping at various intervals to specifically ask if anyone has questions. But this is a lot of information. We're going to be flying through it pretty quickly. I also do want to make sure everyone's aware that I am not an attorney. I'm a public policy director. So I know we have a lot of attorneys on the call. If anyone has questions that I'm unable to answer, I'll certainly get back to you as soon as I'm able to consult with some other folks to make sure I'm giving you the most accurate information. So I wanted to make you all aware, even though we're not going to go through all of the number crunching that was in the state budget, one very important element that was in the 2020 state budget was a $5 million allocation that was set aside specifically to study the current per diem reimbursement funding model that's used to reimburse domestic violence residential programs in the state for the nights that survivors stay in shelter. And we've been talking about the challenges of the per diem structure for a long time. I'm not going to review all of that here today, but what's important is that the state acknowledged that the funding structure that was established pretty much 30 years ago at this point might no longer be the best funding model to flow funding to domestic violence programs. You know, our structure bifurcates residential and non-residential services, and each are funded separately. So the state wanted to engage in a pilot program to look at whether, you know, there are different models for funding these services that might not present the same amount of challenges and paperwork. You know, the administration is that's required for the per diem reimbursements is really extensive. Unfortunately, because of COVID, we haven't been able to get the pilot off the ground. And this, I think, is really a shared view of both the state as well as the 12 or 15 programs that had volunteered to participate in the pilot. With so much fiscal uncertainty that the state is facing because of the pandemic, it probably isn't the best time to actually implement a pilot to look at financial stability and efficiencies. We remain optimistic that the pilot program will happen. I don't think it's going to be put into place before next year, but we'll certainly wait to hear what the state has to say about that, and we'll let everyone know, you know, as soon as we hear anything further on this from OCFS or the governor's office. The other thing I wanted to mention about the state budget is that, you know, since 2020, the state has set aside $3 million of TANF, the Temporary Assistance for Needy Families funding, specifically for non-residential domestic violence services. And we saw that again in this year's budget, the same $3 million. Now, unfortunately, you know, even though the $3 million is in there, it didn't get eliminated, which is great. We also haven't seen that level of money increase in 20 years. You know, if you were going to apply a rate of inflation on $3 million today, it would probably be upwards of $4.5 million. So you certainly can't do the same amount of work with $3 million in the year 2020 that you could do back in the year 2000 when this was initially proposed. So it's one of NYSCADV's budget priorities. It has been for the past several years to try to increase this set aside. But at least it's still set in there at $3 million. So now I'd like to move on to the series of Article 7 measures that are in the state budget. And Article 7 measures are the parts of the budget that relate to policy. And as we've seen under Governor Cuomo's administration, He really does pack the budget with a lot of policy initiatives. It's his way of trying to, further whatever legislation that he's advocating for in the budget. And it's been a very effective means to get his initiatives passed, both in the legislature and then ultimately signed as a part of the final budget. So this year was no exception. We did see quite a few Article 7 measures pass, and actually quite a few are important to the domestic violence community. Now, the budget passes as a series of bills. There are 5 or 6 budget bills that make up the overall state budget. And the first budget bill I'm going to refer to is called the PPGG budget. That's quite an acronym, which refers to the Public Protection and General Government budget bill. And the first grouping of Article 7 measures in the PPGG budget that I want to discuss is really an extension of a sunset clause. So that means there's some laws that's in statute that are set to expire in a certain time frame. And unless the legislature acts, such a law will expire. And what happened this year, as has happened repeatedly over the past, decade or so, I think 20 years, is the legislature took action on 3 important laws to make sure that they did not sunset. And the first was for mandatory arrest. So the mandatory arrest law was set to expire in September of this year, 2020. And in this year's state budget, there was a 1-year extender for the mandatory arrest, so it will remain in effect until September 2021. And this is the law that requires police to make an arrest when they have a reasonable cause to believe that a person has committed a specific crime against a family member. And this is also the law that says police can't ask a victim if they want to press charges against an abuser. Now, what's interesting about these extenders this year, instead of a 2-year extension, which we've seen in the past, the governor and legislature saw fit to only extend the laws for 1 year. Now, I know I've been considering this as well as folks at OPDV. We're not exactly certain why the legislature saw fit to only extend the laws for 1 year. We'll continue to dialogue with them on these 3 laws. I'll talk about the other 2 in a moment. And we'll report back out to you. I think it had maybe more to do with the changing of the guard in the Senate, or potentially some of all the discussions going around bail reform last year. I'm really not quite sure what the justification was, but the important thing is that the mandatory arrest law was continued through September of 2021. The second law that was extended relates to the ability of vulnerable child victims to provide testimony by closed circuit TV. So this is now still in effect through September of 2021, and this applies to children in criminal proceedings who are 14 or younger. And the court would have to find that there's clear and convincing evidence that the child will suffer serious mental or emotional harm if they are required to testify without the use of closed circuit TV. And the third law relates to the maximum lengths of the duration for criminal orders of protection. So the current statute, which was set to expire in September of 2020, permitted a duration of 8 years for an order of protection ordered after a felony conviction, 5 years after a misdemeanor conviction, and 2 years for violations. So those durations for orders of protection remain in effect again until September 2021. Now I'm going to walk through some gun-related measures that were included also in the PPGG budget. And the first relates, it's actually called the Safe Homes and Families Act. This is a new law that permits police to temporarily seize weapons that they see out in the open in plain sight when they're responding to a domestic incident. This is a really important law for us. It also permits police to seize any weapons that they obtain during a lawful search during that response to a domestic. Now, the owner, the individual who owns those guns, can request that that law enforcement returns the gun to them within 48 hours, unless there's been an order of protection issued, if there's been an extreme risk protection order issued, or if there's in another order restricting possession that the court orders, or if there's a criminal conviction which might prohibit gun ownership. And the police can't dispose of any weapons that they seize for at least 2 years. The second gun-related measure relates to a court being able to order an immediate weapons search and seizure if someone refuses to surrender a weapon or for other good cause shown, which I don't believe is defined in the law. And this applies to firearms, rifles, and shotguns. And the court would have to determine there's reasonable cause to believe weapons are located at a particular location. So it can't just be an open-ended search. But if that court does order a search and seizure like this, an immediate weapons search and seizure, it would also couple with it an immediate suspension of the individual's right to possess their license to have a gun. And it requires that the information be conveyed to the DV registry that the court ordered this search and seizure. Now, if a defendant wanted to, they can request a hearing on the search and seizure, which would have to happen within 14 days of the order. The third important gun-related measure included in the budget relates to individuals who commit crimes in other states and then move into New York. And New York has now taken a very strict stand to say anyone who commits a misdemeanor, a serious misdemeanor offense in another state can no longer be licensed in New York to carry a weapon. So essentially, we know that states define offenses in different ways. And the way this law equates those offenses is by relating the essential elements of the offense. So the law now requires DCJS to go through a pretty extensive exercise to look at the offenses in other states and territories and equate those to our offenses here in New York and identify those serious misdemeanors where which would restrict an individual from carrying or possessing a weapon here in New York State. So this is an important measure. I think it's going to take a lot of work to implement, but I think it does, it could be very effective at reducing the ability of individuals who create harm in other states to come into New York and do the same here. And finally, I wanted to talk a moment about the NICS database. Before I do, I'm going to take a drink. So the NICS database is used by the FBI and the ATF and federal prosecutors to restrict people who are convicted of misdemeanor domestic violence offenses from, carrying firearms or possessing firearms. And there's a federal definition for inclusion into the NICS database. And it involves anyone who is convicted of a misdemeanor domestic violence crime, which is a federal, state, or tribal law that has included within it the use or attempted use of physical force or the threatened use of a deadly weapon, and the crime was committed against someone within their family. So there has to be that familial relationship. Now, in New York, we don't have a specific misdemeanor domestic violence crime in the books. So it makes it a little difficult to apply, our offenses here in New York into the NICS database. And our statute has a process identified for getting individuals who are convicted of misdemeanor family offenses into the NICS database. But what we find over the years is that that process that is currently followed isn't really effective. To give you an idea, here, according to the FBI, there are about 300 New Yorkers in the NICS database, 300. In Connecticut, to give you an idea, they've got 30,000. So 300 on the one hand, 30,000 on the other. In New Mexico, a much smaller state, they have 200,000 individuals entered into the NICS database. So why is that? You know, why is it so hard for New York to get individuals into this, you know, federal database? And we don't really know for sure what the difficulty is, but it is a pretty bureaucratic process to get individuals' names into the NICS database from New York. Essentially, what has to happen is a prosecutor must tell a defendant before, you know, the trial or at arraignment, I think it's like 45 days after arraignment, that if they're convicted, there's going to be a hearing to decide whether their crime was actually against someone, you know, that they're related to, a family member or household member, as we define it in New York State statute. Ultimately, if that person is convicted, then the court has to hold a hearing specifically on this issue. And then if it's found that the crime was against a family member, then the court clerk, the court, would send the information over to the NICS database. We've heard that because this is such a bulky process, you know, sometimes prosecutors don't inform defendants that this hearing might happen, so they miss the time frame of notice. And we also hear that judges don't necessarily want to fill up their dockets, which are already crowded with these kinds of hearings, just to get the names in the NICS database. This change in the New York State budget essentially now requires prosecutors to inform defendants that this hearing might happen. So they have to serve the defendant with this notice at arraignment. Before, it was they could, but they didn't have to. It was one of those may versus shall. Ultimately, however, I'm not convinced that this is really going to change to increase the number of names that New York State submits into the NICS database. I'm sure NYSCADV is going to be working on this quite a bit in 2021 because we'd like to ensure that individuals who commit crimes that the federal government has said would make someone eligible for inclusion in the database, that they get included in that database. And just as an aside, I'll let you know the reason why Connecticut is so effective at getting individuals into the NICS database is they don't have a hearing or any kind of separate process at all. They merely use their version of the domestic incident report, our DIR, to prove the familial relationship. So there is no court hearing, no proceeding. It's just based on the information on their DIR. So I just want to stop for a moment there. I know we covered quite a bit before I move on to some of the other Article 7s. Check my time here a little bit. Jen, is there anything in the chat I should be responding to?
There were a few comments. There is one related to the child witness law in New York State. The question specifically was, how does this law pass muster regarding the US Supreme Court decisions? So I think we might need a little bit more information. If you could just refer back to, for Chris who asked this question, if you wouldn't mind just including some more information of what decision you're referring to. We also had a comment about closed circuit TV laws sunsetting every year in the chat box from Judith.
Thank you, Judith, for your comment on it. I'm just reading it now. You know, I don't think I really understand why the legislature has set up a number of laws. I mean, it's certainly not just these that are set to sunset every year or every couple of years. I think it was meant to keep the statutes evolving, you know, so Instead of requiring new legislation to repeal, it would automatically sunset. But I'm really not an expert on those issues, so I'm sorry I can't be more helpful with that. But as I said earlier, it was definitely a change in the measures that I already spoke about that used to be extended on a 2-year cycle, and now we only saw them on a 1-year cycle. And I'm going to have to do a little more sleuthing on that to understand why the governor and legislature felt that was necessary this year. And as soon as I have more information there, I'll share it. So I'm going to keep going. I want to be sensitive to time. We've got a lot more to cover. One of the things that the budget also advanced related to equitable distribution of assets during divorce. Now, domestic violence was already a factor in determining temporary or post-divorce spousal maintenance to the extent that domestic violence had inhibited or continued to inhibit a party's earning capacity or their ability to obtain meaningful employment. What this measure does is that it breaks the domestic violence factors from, someone's earning potential in the future. And it essentially says that the court can consider whether either party has committed an act or acts of domestic violence and the nature, extent, duration, and impact of those acts. So just because domestic violence happened is something that the court can consider. It doesn't also have to impact an individual's ability to get a job or to make money down the road. Now, some of you might be familiar with a new law from 2019 that was called the Safeway Home Act, which essentially permitted free rides homes, well, authorized, I should say, free rides home from medical facilities for rape victims and advocates. And we thought this was a great law. We advocated for it along with our sister coalition, the New York State Coalition Against Sexual Assault. And that law gave the responsibility to fund the free transportation to OVS. What happened over this past year is that I believe, I don't want to speak for OVS, but I think there was some concern about having the funding for the free transportation reside within OVS. So there was an amendment to the Safeway Home Act. They actually repealed the 2019 law and instituted a new law, which says now only the sexual assault victim, no longer the advocate, can get free transportation. And those costs must be borne directly by the rape crisis or victim service organization. Now, there was no additional funding provided to the rape crisis centers or victim service organizations with this new law. We think this is really quite a concern. We certainly agree that rape crisis victims and their advocates should have free transportation home. But we think it sort of amounts to, unfortunately, an unfunded mandate for rape crisis programs, which are already very underfunded to cover these costs, which could be pretty extensive in some communities. And NYSCADV has done some extensive research on what those costs might be. So we're going to continue working on this with NYSCADV and New York State to see if we can't try to resolve the funding issue on this new law. Another Article 7 I just wanted to quickly bring to your attention relates to training with respect to the needs of elder LGBTQ individuals. And this requires the New York State Office of Aging to make elder LGBTQ training available to all of their local aging agencies. And, I think this is just a tremendous move in the right direction to recognize the needs of elder LGBTQ individuals. It will, minimize barriers, I hope, and improve services. I think the more people understand their specific needs, then certainly the better we can enhance service provision to that community. And we had some more refinement on the provision of post-exposure HIV medication, the prophylaxis medication. You might recall that there was some work on this in 2019, and this sort of amends the amount of medication that could be available and receive compensation for OVS to pay for it. So essentially what the medication enables anyone who might come into contact with someone carrying HIV to lower their infection if it's taken. And by some accounts, it can lower the infection rate by 80%, which I was pretty surprised to see that. I didn't realize it was quite that effective. But they have to start taking the medication pretty quickly, within 3 days. So this amendment now allows for a 7-day starter pack for anyone who's 18 and older, for sexual assault victims, and the full regimen, which is a 28-day, for anyone who's 17 and younger. And it also clarifies that victims do not have to present their health insurance information, but OVS will cover the cost for the medication. So I'm going to talk briefly about bail reform, and I think those two things sort of oppose one another. How can you talk about bail reform briefly? Because the changes are so extensive. Last year at this time, we were reviewing the comprehensive overhaul of bail reform. There were some additional amendments in the 2020 budget to the bail reform, the 2019 laws. That's why I'm trying to refer to them as amendments to keep myself straight. This is in no way a comprehensive review of every change that was made in 2020. I really only picked out the specific measures that I thought would be most important to all of you. But certainly if anyone has more questions about any of this, we can certainly talk more. So first, the amendments expanded the crimes where bail and pretrial detention could be ordered. So as you can see on the slide, the amendments made some misdemeanors bail eligible, including criminal obstruction of breathing or blood circulation when it's committed as a domestic violence offense. And it expands nonviolent felonies that were eligible for bail and remand, including the unlawful imprisonment of an individual if, again, committed during a domestic violence incident as a domestic violence crime. And finally, with regard to strangulation in the second degree, this was already included as bail eligible in 2019 because it's designated a violent felony. But the 2020 amendment specifically calls it out as bail eligible or eligible for remand. Now, the 2020 amendments also broadened the categories of those who are eligible, the types of individuals eligible for bail or remand. So now if someone is charged with a felony while they're on probation or parole release supervision, then they can be ordered for bail or remand. Persistent felony offenders, and those who commit crimes after being convicted on another crime but awaiting sentencing. So if an individual falls in any of those categories, then they can be eligible for bail or remand. And the 2019 reforms introduced the idea of non-monetary conditions that could be used pre-trial. So in 2020, the list of these non-monetary conditions was expanded. So now the conditions include a refrain from associating with victims or witnesses. The court can order an individual to participate in programming through a pretrial service agency, which could include counseling, treatment, or interestingly, intimate partner violence programs. The court can order an individual who's released to obey an order of protection. And specifically for domestic violence offenses, the court can order an individual to obey conditions that would address the victim's safety, including ones that are requested by or on behalf of the victim. And just turning quickly to discovery, again, a lot of changes, amendments to discovery. I'm only nitpicking picking out those that I think are directly relevant to those on the call today. You know, the changes here are really quite significant, and I just don't have time to go through all of them. But the important change is relates to contact information and names of victims and witnesses. So now the prosecution, essentially, well, any party, but assuming it's the prosecution, can decide to withhold information about witnesses, victims, 911 callers, if they tell the defendant that they're withholding that information. However, if the prosecution seeks to use the testimony of that witness or victim, then they have to disclose the individual's name and contact info within 15 days before the trial or the hearing. Now, the defendant can make a motion for a more timely disclosure, and the court would have to hear that. But so now, you know, it gives that prosecution the ability to withhold the contact info and name of the individual, at least for a period of time. And if they don't intend to call that witness, then they never have to disclose it. The one thing I did want to mention, I'm just looking at my notes here quickly, is that there is no change in the 2020 amendments to the ability for parties to request a protective order if they want specific information withheld. So I'm not going to review that whole process, but that's still, even with this amendment here, you know, either party can still ask the court for a hearing on a protective order for any information that they don't want shared. The other thing I just wanted to quickly mention is that there's no change for the ability of a defendant to request access to a crime scene or other premises related to a case. So that hasn't changed either. So that takes us through the bail reform and discovery pieces I wanted to cover. I know we're getting a little tight. I need to start talking a little faster. I did want to mention quickly that one of the Article 7 measures contained a comprehensive paid sick leave act for all individuals, but I just wanted to make sure all of you were aware of it too. There's a lot of different criteria and eligibility factors with respect to the requirements for employers to provide the time, as well as the ability for employees to access the time. So I did give you the link to New York State's website if you wanted to find out more. There's a lot of information there, including FAQs. But essentially, the law is carved up to for employers who have 5 or fewer employees and who make less than $1 million versus employers who are larger with 5 or more employers and who make more than $1 million. And employees have already begun accruing time as of September 30th at a rate of 1 hour for every 30 hours worked. And they can start taking time, start using that accrued leave by the on the first of the year. So I think that covers everything in the budget. As I said, there was really a lot of Article 7 measures. Thanks, Jen, for adding the link in the chat to that program, to the paid sick leave website. So now I'm going to get to the specific pieces of legislation that initiated in the Assembly and Senate. We're going to talk first about the laws that have already been signed, and then I'm going to review some of the bills that we're hoping will be sent to the governor soon for his signature. So the first new law that I wanted to let you know about essentially adds smart home tech abuse to orders of protection. So this permits the court to restrict any party to an order of protection from remotely controlling connected devices of a person who is protected by that order of protection. So connected devices would include any kind of device that can control a home, a vehicle, or property. So these are the security systems that can unlock and lock doors and windows, thermostats, cameras, it's the Alexas of the world, the voice activated assistants, lights. So this is a pretty important measure. I don't think it's gotten a lot of attention because of all of the COVID issues that we've all had to deal with this year. But this is really great for domestic violence survivors, and it is effective immediately. We also had a pretty important law passed relating to an assessment of the services available for human trafficking survivors. So you might remember that back in 2018, there was a new law then that required culturally competent housing and services for human trafficked survivors. And those services included healthcare, in addition to housing, healthcare, mental health counseling, substance abuse treatment, language interpretation and translation, and job training. So it was a pretty comprehensive law. And the legislature even followed up with a $2 million allocation in the 18-19 state budget for safe houses for trafficked survivors. So this new law follows on that 2018 law to really look at where the state is at with respect to the provision of housing and services for these survivors. So it requires OTDA and DCJS to compile a report looking at a number of different factors, including the number of survivors who received housing or services and all the types of services that they were able to receive. It also has to look at why individuals didn't obtain housing or services, and also to look at the overall availability of housing and services statewide. So this law becomes effective in May of next year, and then the report is due 1 year later, so May 2022. But I think this will be very helpful for New York State to assess its success at implementing the original 2018 law. There's another law that relates specifically to the enabling statute for OPDV, our New York State Office for the Prevention of Domestic Violence. And this new law actually does two things that are somewhat unrelated. The first is that it adds a new chair at the table of the OPDV Advisory Council for the Commissioner of Homes and Community Renewal. And this is, our housing agency, essentially. And its mission is to create affordable housing. So this is really a recognition that many survivors have a priority need for housing. And we have a dramatic shortage of affordable housing in New York State. So, this is a real positive, and we think will help inform the work of the Advisory Council by having this individual participate. The other thing this new law does is it repeals some pretty outdated language in the statute that referred to a batterer's project. And the batterer's project, some of you who have been, working in this movement for much longer than I have, might remember back in the 90s, OPDV had a pilot project with, I think it was 5 batter intervention programs across the state to look at, best practices and effectiveness. That project hasn't been funded for many years, 20 years at least. So this was just a way to sort of clean up the statute a little bit, since it was so outdated, to remove it. A lot of the language was really quite outdated. So this repeals that old statute, and in its stead, under the responsibilities for OPDV in the statute, it now includes a responsibility to promote abusive partner intervention. So we know that OPDV has been really focused on batterer intervention programs. One of the recommendations that came out of the Emergency Domestic Violence Task Force earlier this year was sort of a multi-pronged approach for dealing with abusive partner intervention. There was a recommendation to potentially create a hotline for abusers, or maybe a helpline. It's a little unclear if it's a hotline or a helpline, but also an effort to maybe think through either guidelines or best practice for batterer intervention programs or abusive partner intervention programs. So, this now puts that work within the statute of OPDV responsibilities. And this is effective immediately, but as we've seen, OPDV has already been working on this, and actually OPDV has a specific working group that NYSCADV is participating on, working on these issues. One new law, actually, the governor just signed this within the last couple of days, doesn't really relate specifically to domestic violence. And I wanted to raise it because I think there was some confusion on whether it does relate to what we call abusive litigation, the ability of abusers to just keep filing claims, to keep their victims in court where they could see them and continue to harass them. This is referred to as the anti-SLAAP bill, which has now been signed into law. New York State had some laws on the books to protect certain individuals from nuisance lawsuits, but the statute was really very narrow. And in the implementation, it really only applied to some real estate permitting, and public activities. So essentially, if someone were to say something in a public arena, at a public meeting, this, the very narrow interpretation of our earlier law would restrict large companies, big developers, from, harassing individuals who might be opposed to their projects by throwing a lot of court proceedings against them. And they, these individuals who felt strongly about these projects might not have a lot of money to, continue get attorneys, for all of these court proceedings. So what this new law does is it broadens the definition of public interest. So what the cases that would fall under these protections. But the reason this is important is because it really only applies to court proceedings or projects of public interest. So it really does not address the private actions that an abuser might, all of those court cases that abusers might file against a victim would not be addressed by the anti-SLAAP legislation. So it's still a very positive law, but I have heard some questions about it, so I wanted to put it in here because I think we'll need to work a little bit more on protections for survivors with respect to abusive litigation. And if anyone has suggestions or ideas on how we might go about doing that, I'd really love to talk to you. One of the important bills that passed, that was signed into law in 2019, required hospitals to have a more comprehensive plan for the identification, screening, and treatment of domestic violence survivors. And it also included a pretty hefty training component for healthcare staff. There was an amendment, sorry, that was my dog. There was an amendment to that law this year to clarify which hospital personnel has to participate in the training. And essentially it carved out the administrators and the people who are not providing direct care to patients. So it doesn't change in any way the substance of the law for individuals who are delivering direct care. The other law that I wanted to make you all aware of, if you hadn't heard, relates to the 2019 Child Victims Act. And one of the things that the Child Victims Act did was it permitted a 1-year look back. So there's some statute of limitations requirements for anyone who wanted to file either a civil or criminal case because of child victimization that happened years prior. There was, within that 2019 law, the ability for any victim, regardless of whether a statute of limitations had expired, to file a claim. But because of COVID, we know that individuals' ability to find attorneys and to actually file claims was really impacted. So the legislature and governor has approved an extension of that 1-year window, and claims can now be filed through August 2021. And just to give you an idea, I believe that from August to December of 2019, we had 1,300 civil suits filed. So there's certainly, a lot of interest in this law. So I think it's great that, victims were given this additional time in order to file claims. So I'm going to march through a couple of other laws very quickly before we go to, before we talk about the ones that are still waiting for governor action. I'll stop again and make sure there are no questions I need to address. There's a new law that requires all bathrooms in state-owned buildings to be gender neutral. There's also a new law that expands the eligibility for OVS compensation to domestic partners. And domestic partners is defined as, if someone's a beneficiary under another person's health insurance or receives their employment benefits, if there's common ownership of property, if they have children in common. So that's a expansion of the definition of a domestic partner, which is great. There's a new law that that requires a reasonable accommodation for individuals who have disabilities to be in housing with their animals, if the animals help them deal with their disability. So not quite elevating to a service animal, but if there's an individual who has an animal who helps them in some way, then they are permitted to have the animal with them in public housing, as long as it's not an undue burden for them to be there. Oops. And there's also a new law that permits tenants whose landlords decide they're just not going to pay the water bills or utility bills from actually reducing their rent by that amount of money. So if, a landlord is taking money from their tenants with the understanding that they will use that money to pay these bills and then fail to pay the bills, then tenants can just deduct that price from their rent. Okay, so, I think I'm going to break here. I see some stuff in the chat box. Jennifer, is there anything I need to be addressing?
Yes, we do have one question going back to the Safe Way Home Act, asking specifically, within the act, does it limit the distance of travel home? For example, within, say, county limits only?
Not that I'm aware of, which I think is sort of raises some of the question about the true costs of that new law. But I think I want to sort of defer to my friends at NYSCADV on that and maybe get back to everyone with an answer there. But I don't believe there is a restriction to county lines or other geography. The only thing I'm thinking is that it could include the service provision area of the hospital. It could include that, but I'd have to double check.
And Joan, I do see that Ellen Shell just responded in the chat box that there was no limit in the act.
Thank you, Ellen. Thank you so much. Thank you, Ellen. Okay, so I wanted to point out that one of the things that the legislature did was pass a number of laws specifically in response to the pandemic. There's the suspension of forfeiture of unemployment benefits. The Department of Health is going to do a study of why COVID seems to disproportionately impact minorities. There's been a lot of action with forbearance of mortgages as well as evictions. There was also an effort to ensure that contact tracers in New York City represented the cultural and linguistic diversity of the communities that they were working in. So there was really a lot of work that was done in response to COVID. And I suspect that when the legislature returns in 2021, that we'll see some additional efforts there as well. One of the other reasons that the legislature saw fit to come back to Albany briefly was to respond to some of the issues that were elevated as a result of the George Floyd murder. This is not the full package of police reforms. Again, I just pulled out the ones that I thought were most resonant. But there's, New York City had already prohibited the use of chokeholds, and that prohibition has been expanded statewide. It's referred to as the Eric Garner anti-chokehold. We also now have access to police disciplinary records, and individuals who are witnessing police activity are able to videotape that activity and own that video. No one can take it from them. As well as a requirement, I thought this was particularly important too, that anyone who's in custody has to be provided medical and mental health attention while they're in custody. So law enforcement has to provide that. And just going up to this top bullet here, I skipped over that intentionally because there was a case some of you might have heard coming out of New York City where there were two people in a park, and there was a Caucasian woman and she was walking her dog, and despite numerous signs around the park requiring dogs to be leashed, her dog was not leashed. And a Black man approached her and asked her to put her dog on a leash, and she threatened to call 911 and say that a Black man was harassing her or threatening her. So this new law relates specifically to that. It establishes civil penalties for calling 911 due to someone's race or ethnicity or gender. And I just wanted to clarify, I did get some questions about this law with respect to, does it restrict a survivor's ability to call 911, or would it cause law enforcement or anyone else to suggest that there wasn't justification for calling 911? I really don't think this law will in any way impact that. I think it's a very narrow purpose to essentially create these civil penalties if no crime has been committed, but if someone is trying to use 911 essentially to harass another individual due to their race, ethnicity, gender, or their status as any other protected class, including a domestic violence victim. So I wanted to talk about some of the bills that are awaiting governor's action. One is a bill that NYSCADV has been advocating for the past couple of years, which is referred to as the Comprehensive Broadband Connectivity Act. And this essentially requires the Public Service Commission to study the availability, affordability, and reliability of broadband and fiber optic service. Now, this bill was introduced years before COVID, but this is so critically important now. We know that there are communities throughout New York State that just don't have internet service, reliable internet service. And, our children are now going to school online. We're all working from home online. So this couldn't be more critical. To me, this is top of the list, and I really hope the governor does sign it. In addition to requiring this report of, the areas that are served, whether they're unserved, not sufficiently served, pricing, it also requires at least 4 public hearings. I mean, I don't know if these would be virtual at this point, but at least it's in there that there has to be 4 public hearings to solicit stakeholder input on, the accessibility and availability of the internet, as well as requiring the PSC to then work with internet providers to prioritize access to areas that don't have sufficient internet service. So the way the bill reads, I gave it to you there, it's any community that has negative economic and social impacts due to absent, insufficient, or inadequate broadband or fiber optic service. A couple of other priorities of NYSCADV's was on having personnel from ICE in courts. This is an action that the governor has taken very seriously, so we are optimistic that this will be signed. And this it ensures that anyone who is attending court, whether it's a defendant, a witness, a family member of a witness, that they can't be arrested for civil prosecution. So this carves out civil from criminal, but they can't be arrested for civil prosecution while attending that court, unless there's a judicial warrant or a court order. So that's the differentiating factor there. I'm just referring to my notes here. It also permits the Attorney General to bring a civil action if someone violates this, or a federal agency violates this. And it requires the Office for Court Administration to prepare an annual report to compile statistics about the use of judicial warrants or court orders in this regard. Another bill that we're hoping is signed provides a right of action for the unlawful dissemination or publication of sexually explicit images or depictions of individuals. So you might remember one of the important laws that was passed in 2019, we referred to as the revenge porn law, which criminalized the intent to distribute images that were obtained under a reasonable expectation of privacy. So this now creates a right of privacy. Really, it creates a right of privacy to deceased individuals. So these images can't be used after someone's death. And it also addresses the ability of technology to create digital replicas of images and manipulation of images. And finally, there's a bill that also hasn't gotten a lot of attention, but we think is really important to everyone who's incarcerated, but certainly incarcerated survivors, to ensure that if someone's a parent and they're incarcerated, that they be placed at a facility closest to their children. And that's not only for the incarcerated individual, but for the children's health and well-being as well. So before we look at 2021, Jennifer, is there anything more I should be addressing? Or I just want to give everyone a few seconds. If there's information, questions, please put it in the chat box and we can address it.
Thank you, Joan. And I do have one question with respect to requirements for training hospital personnel. Does it outline what has to be covered during the training and how it's delivered and who it's delivered by?
Great questions. I believe the state is going to be working on a template for the training. If I'm not mistaken, and Ellen from OPDV, you can certainly weigh in the chat box too. I believe OPDV and the Department of Health is working on that. And I'm hoping that domestic violence advocates would be able to weigh in on that template before it's finalized. One important aspect of the law that I didn't review is that it does require hospitals to reach out to the local domestic violence program in their service area and, establish a relationship if one doesn't already exist, or foster that relationship. The hospital is required to designate someone within their staff, on their staff, to serve as a liaison, all with the goal of enhancing services for domestic violence survivors. So, I think it's our hope at NYSCADV that the fostering of that relationship and the enhancement will lead to a collaboration on the training of staff, where maybe, it's domestic violence advocates alongside hospital personnel offering that training. But it's not, the law doesn't specify who at the hospital would actually offer the training. Anything else, Jennifer?
Not so much pertaining to laws. There is a few comments that we can follow up on.
Okay. All right. So I just wanted to give everyone some insight into what we're thinking about for 2021. This could certainly change, of course. And, at the top of the list, and I didn't put this on the slide, but I think it sort of goes without saying, is, ensuring that domestic violence survivors and service providers have what they need during COVID, whether that's accessibility to services or funding. We continue to work with New York State. I think we have weekly discussions with folks at various state agencies to talk about the funding issues that domestic violence service providers are facing right now, as well as the increased demand for services that we're seeing in so many communities across the state. So these are issues that are really very top of mind. I think for both New York State as well as NYSCADV, and I'm sure many of you. The one thing I'd like to really implore any of you out there, if your program is experiencing significant financial distress because of the changes with respect to occupancy rates at shelter or any other reason, the 20% hold on contracts that the governor has announced, please let us know at NYSCADV or reach out to OCFS or OPDV to let them know, because it's like I said, it's certainly a priority for all of us, the entire community, and we really would want to be sure that we're doing everything we can to assist in those kinds of situations. So as I said earlier, part of the budget included a $5 million pilot on the per diem funding model. We're going to continue to work with New York State to ensure that that's implemented at the right time. We don't know when that will be, but as soon as we think that it should be implemented, we'll ask New York State to move forward and work with them to implement the pilot project, one that could really assess the best way to fund residential and non-residential services in New York State. I did want to mention some of the work that we've been engaged in on issues pertaining to family court. There's been a lot of interest in, really focus, I should say, on some of the tragic outcomes that have occurred in recent years in family court. The Times Union, the Albany Times Union, did a great series earlier this year that focused on a few families and outcomes. And I've been working with a network of survivors who frankly have survived family court, or maybe not. Out of all of that work, there's been a lot of interest by legislators to try to improve outcomes for domestic violence survivors and their family members. So I've listed here some of the bills But I just wanted to convey to all of you that I think you're going to be hearing more and more about efforts to improve family court with respect to the assessment of best interests of a child, what that really means, supervised visitation, judicial training for child custody evaluators, and the quality of the reports that they prepare, as well as the sharing of those reports for domestic violence survivors and attorneys. The ability to get a copy of those reports really varies statewide. And we view it as a due process issue. We think domestic violence survivors should be able to have a copy of a report that talks about them. So those are the kinds of issues that I think you're going to be hearing about more and more, and we're going to be continue to work on them next year. One of the bills that we really focused on as part of our 2020 virtual legislative day of action related to extending the privilege that's provided to rape crisis counselors to domestic violence advocates. And I think you're probably familiar with this bill. I've heard pretty broad support for it across the community. We think that it will decrease a lot of requests from service providers for evidence and file records. And we also think it's difficult for survivors, particularly if they're at a program that offers both domestic violence and sexual assault services, that they can talk to one person on staff and their conversation would be privileged, and yet they talk to another person and it's not privileged. So this is a bill that has passed the Senate a couple of years in a row, and we're hoping to really make inroads in the Assembly this year, in 2021, and get this signed into law. We also think that it's important to really do more to bolster the rights of incarcerated survivors. There's a couple of bills that we're supporting. One would give a lot more teeth to the health program for incarcerated women, which we think is really important. And there's another bill that permits incarcerated survivors who are delivering children in labor to have a friend or family member present with them. And frankly, I think it's appalling that that's not permitted. So we think those are pretty important pieces of legislation. There is a cyber sextortion bill that's been around. We're hoping to get this to the finish line in 2021, which, we already have criminalized the dissemination of intimate images of individuals. This would include or expand that to include threats of dissemination, because we know the threat of an action could be just as important as the actual action itself. So that's the cyber sextortion bill. There's a bill to expand the definition of aggravated harassment to include text and email and other electronic correspondence, which we think is really important because, who's harassing people by the phone anymore? I mean, you have your cell phone, of course, but we know that survivors are harassed day in and day out by text messages and emails, and those should be included within the evidence of an aggravated harassment offense. We are continuing to work with a coalition of partners to advance a K through 12 curriculum on healthy relationships. And this is called different things. We refer to it as a healthy relationship curriculum. Others refer to it as sex education, but it really does the same thing. It's very important that it's K through 12. Frankly, we'd like to see it even prior to kindergarten. But this, is just such a critical aspect of the education of our youth to understand what's appropriate and what's not appropriate. So we're going to be, working to advance this legislation as well. There's a new effort afoot that we joined a coalition to raise the age of consent for marriage to 18. You might recall that we recently raised the age to 17. Some folks thought that was a fantastic measure. Others felt it didn't go far enough. So, you know, I'm sort of in that camp that I don't think you should be getting married before you're the age of 18, whether you have parental consent or not. So NYSCADV has joined that coalition, and we're going to be advocating for that bill. There's a bill, actually, one of our local programs brought this bill to our attention because of a particular circumstance in their community, which is making sure that someone who is a witness in a proceeding or is working with law enforcement does not have the capacity to consent to sexual engagement with that officer or the supervisor of that proceeding. There is a law to ensure that New York State provides internet service to any individuals within shelters, and that includes domestic violence shelters as well as homeless shelters and youth facilities. So we are strong advocates of that. And I will say that, you know, I think that the state has tried really hard in the COVID world that we're now in to ensure at least domestic violence shelters have the internet services that are needed. I know funding is a big issue, and we are still waiting for the state to make some grants available for new technology that they mentioned is in the works. So we're waiting with bated breath to get that approved. But this, you know, would require, and this is another bill that I think this one actually came out of COVID, but just to ensure that, you know, the state is really required to provide this because it's so critically important to individuals in these types of shelters. And then the last two things I just wanted to mention to you is we're going to be continuing to dialogue with all of you and other stakeholders on coercive control. There's some interest on the part of the legislature to create a crime of coercive control. There's differing thoughts on this. I think NYSCADV's position right now is we don't really want to see additional crimes created to try to respond to domestic violence. Particularly coercive control might be very difficult to prove. It might be easy for abusers to turn the tables on victims and make them appear to be the ones who are coercively controlling the other. So I think there's a lot more discussion needed on coercive control, and we'll continue to work on that in 2021, as well as the decriminalization of prostitution and anti-loitering bills. So these, actually the decriminalization of prostitution legislation was being discussed quite a bit in early 2020, but then got derailed because of the pandemic. So we're going to be engaging a lot more in those discussions. I don't think NYSCADV has a position on the decriminalization yet. I think we need to do a little more work and a little more talking. So if, you know, anyone would like to talk about either of those coercive control or prostitution and anti-loitering issues with us, you know, just please reach out. You'll see my contact information at the end of the slides. And before we break for questions, I think we're right on time here. I did just want to point out to let everyone know, I think in some of the registration materials, someone had suggested, well, you know, this is great. Tell us what you want us to focus on and tell us how. So this is my slide to tell you all how. Save the dates. I can't quite put out there yet because I think in this virtual environment that we're in, I don't think we've actually settled on dates yet for our 2 annual events, which is our February Budget Advocacy Day, as well as our Legislative Day of Action in May. We will be having both events, but we have decided for sure the Budget Advocacy Day will be virtual, and I'm fairly certain the Legislative Day of Action in May will be virtual as well. but I'm hoping that even in our virtual environment, you'll be able to join us. I will say that our 2020 virtual day of action, I think had more participants this year, I think, than we have when it was in person, because I think so many of us just have a little more availability being tied to our computers at home. And it was a little easier than requiring everyone to, get to Albany and participate, even though I love seeing everyone. And I think we're really effective when we get together in Albany for both of these events. So regardless of what our specific activities are for those days, I'm hoping you'll, decide to join us to whatever level of involvement you have available to you. So I see some activity in the chat, Jen. Can you help me with it?
Yes, there were a few things related to from one of our attendees regarding a law, which if you might want to read it. It's a legal proceeding. One question I did see, and I've gotten a few comments about, just so everyone is aware, the recording as well as the presentation slides and a link to the Family Court Series article that Joan is referencing from the Times-Union. There will all be sent out in the follow-up email. I did also just put the Family Court Times-Union article series in the chat box.
Great. And excuse me, Chris, I see your notes here about 240.30 in the penal law. I'm going to have to take a little closer look at this, but I'm happy to talk more to you about it. I think might be talking next week, so maybe we could add this to the list. But I'll take another look, a closer look after the webinar. Well, I think that's it. Robbie, I'd love to work with you more on the mandatory surrender of firearms in OP stage, and really just an appeal to all of you. I'll put up the slide here with my number and email. I know we've had a chance to meet, many of us, but there's still loads of relationships to foster. So feel free to call me at any time to talk about issues that you think are important, whether they're on these slides or not. I'm always available, as well as my colleague Jane Nee, who's participating today too. So if there are issues that you'd like NYSCADV to focus on or to amplify, even if you have a suggestion for a bill, if you're dealing with a survivor who has a particular need, or there's, some gap that you've identified, I can't tell you how much it helps our work at NYSCADV to be informed by your work. So to the extent that you have time to, give us a shout and let us know what's concerning you or the questions you have, it's so helpful to us. So please feel free to do that. You're not being a pest, you're not being a pain. I really would love to talk to you about those issues at any point. So I think we'll go ahead and just leave the chat line open here for a few minutes, make sure nothing else comes in. But I think for the rest of you, I think we'll call it a day, and we'll make the slides and recording available in the next day or two. So thank you, everyone. Enjoy your Friday the 13th.